All rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Marilyn Zayas presiding, is now in session. Please be seated.
Good morning, everyone.
All rise. The Court of Appeals.
Morning.
Good morning.
So today is Thursday, September 25th. Welcome to the First District Court of Appeals. We have one case that is going to be heard via virtually this morning. And before I begin calling the case, I hope everyone had a good Rosh Hashanah.
Thank you, Your Honor.
And thank you for accommodating and allowing for the case to proceed as it is this morning. So the case that we're going to be hearing this morning is the case number C240644, which is Nanette Kelly versus Edward S. Horton, Dr. Edward S. Horton et al. If attorneys can please identify themselves, their readiness to proceed, and I do understand that for appellee, there's going to be two attorneys arguing, splitting time.
That's correct, Your Honor.
Good morning, Your Honors. My name is Kendra Davitt. I'm from the law firm Flowers and Grube, and I represent Nanette Kelly.
Okay.
Good morning. I'm David Calderhead. I represent Dr. Edward Horton and his group Tri-State IMG.
And Attorney Calderhead, you'll be arguing first?
Mr. Goldwasser will.
Okay. And who's going to have the extra minute with the split? So 8-7.
Brian Goldwasser, Your Honor, on behalf of defendants, doctors, contractor, and Group Health and Tri-Health. We are ready to proceed, and we will proceed first with 8 minutes.
Okay. Okay, wonderful. Attorney Davitt, would you like to reserve time?
I would like to reserve 3 minutes, please.
Right. And you can start whenever you're ready.
Okay, I just wanted to thank you also for accommodating my schedule because it involved travel plans, and I really appreciate that you allowed us to do this.
No worries at all.
Okay.
Happy to do it.
Yeah, I represent Nanette Kelly, who filed a medical malpractice action in the Court of Common Pleas after she lost vision in her right eye due to a delayed diagnosis from the defendants in this case. At the time she lost her vision, she was only 51 years old, and the doctor's nonchalance about her worsening symptoms led to a delay of care and a lack of her ability to seek additional treatment or additional options. There are two assignments of error, and they kind of flow together. The first is regarding the admission of a learned treatise into evidence without a sufficient foundation. And it really is the heart of the plaintiff's case because it goes to the causation and what the standard of care was for Dr. Contractor. If you'll recall, there were two physicians. Dr. Contractor was the neurologist who Ms. Kelly was referred to because of some worsening blood panels that she was getting from a rheumatologist. And she'd never seen a neurologist, even though she'd had a long history of migraines. And she was having some atypical migraine symptoms. Typically, I don't know if any of you have ever had a migraine, they're always in the same place. And this was in a new location. It had different symptoms. It was of a different intensity, and it was painful to the touch. And there's two different kinds of MRIs. One is—
I believe the record is clear that she shared that with the physician at that time.
Did she share what, Your Honor?
That it was in a different location and how it was different to what she had previously experienced.
I believe so, Your Honor. There was a lengthy questionnaire that she filled out for Dr. Contractor, and I don't have it in front of me, but I believe she indicated the locations of her headache and the number of headaches she was having, how they were increasing in frequency and severity.
Counsel, you indicated that this issue around the learned treatise was really at the heart of the appeal. So I'd like to jump into that. How do you address the harmless error response to that issue?
Well, I don't think it was harmless at all because it completely eviscerated the plaintiff's standard of care expert who testified that having an MRI with contrast is the basic standard of care in this situation. And when you have an MRI with contrast, it illuminates any tumors or abnormal parts of the brain that aren't like they should be. And so when they did the MRI without contrast, it kind of blended into her sinus cavity and other parts of the brain, and it wasn't as easy to see. And if she had done it with contrast, it would have been immediately apparent that there was this growing tumor that was that eventually compressed her optic nerve and led to her blindness. And so the learned treatise that the defendants introduced was actually not a learned treatise.
Can I ask a question real quick? Sorry,
Of course.
I haven't done Zoom in a while and I was muted.
It's kind of weird. I feel like my eyes are all over the place.
I know I was getting really good at this during COVID. So is what your real issue on this assignment of error is that there wasn't a foundation properly laid?
Well, I don't think it was a learned treatise at all. It was when you see in the record during trial counsel's objections, it was just a set of guidelines that the American College of Radiology updates. And it's not technically a learned treatise, I think. But even if it could be considered a learned treatise, there wasn't a proper foundation. None of the expert witnesses had used it in forming their opinions. It was never discussed until defense counsel brought it up on cross-examination, and the court didn't take any judicial notice of it, and nor was it requested.
But
So-
isn't part of the problem here?
Oh no, you
Oh.
froze, Judge.
I know. Isn't part of the problem here that the objection that was raised in, I believe that everybody went in chambers, wasn't what you are now arguing on appeal?
Well, I don't think so. When they went into chambers, I believe Mr. Goldwasser was the one questioning at the time, although I could be wrong. It might have been Mr. Calderhead. And he said, "Have you heard of the American College of Radiology?" And trial counsel immediately objected. And when they went into chambers, he argued relevance because there was no basis to bring this up. It had never been discussed. And Dr. Mankowski is a neurologist and not a radiologist. So what a group of neurologists says, or what a group of radiologists says, is not necessarily impactful of his study. I mean, if you think about having an affidavit of merit for a medical malpractice claim, I'm sure if plaintiffs filed a claim and were contesting a neurologist and provided an affidavit of merit from a radiologist, the defendants would immediately move to dismiss because they're different specialties. So I don't see how the criteria, which aren't even from a learned treatise, can apply to cross-examine a specialist in a different field. Does that answer your question a little bit?
Well, I'm just trying to understand if the objection below is the same as what you're raising on appeal, because it sounds like on appeal that you're saying that they never established that this was a learned treatise, and I don't recall that being an objection below.
I believe there were 3 points when trial counsel objected. The first was at the time of questioning, and he argued that Dr. Mankowski had said he was only generally aware of the document and it hadn't met the 3 criteria. I think he argues later when they admit the evidence, or when they were, I'm not sure if it was when they admitted the evidence or when they were on a break and he raised the objection again. He did it on page 903 of the transcript and page 1292. And I believe it's the one on page 903. It's a very lengthy objection. He goes into the entire inappropriateness of the lack of foundation. It was well argued. It took several pages. And I'm sorry, I can't remember which is which, but there were 3 times he objected to it, and he definitely raised that argument below.
Counsel, what other evidence was presented by the defense other than the learned treatise that there was no malpractice in this case?
Could you repeat that? I'm sorry, I missed just a...
What other evidence was presented to the jury by the defense that there was no medical malpractice?
I mean, I
other than
think
the
there...
learned treatise?
through the learned tree, other than the
Other
learned tree.
than,
I mean, I think that flows into the second assignment of error when they kind of tried to point fingers. Initially, they were pointing fingers at each other, and then they pointed fingers at Miss Kelly by saying she didn't
counsel,
follow.
I'm just specifically focused on the testimonial evidence. Was there other testimonial evidence from medical experts refuting the claim that there was malpractice?
No, I don't believe so, Your Honor.
What about Dr. Contractor?
Whether she provided any evidence.
Correct. Did she provide any expert medical evidence that there was no medical malpractice?
I believe her expert was Dr. Volpe.
No, herself.
Oh, herself. I mean, she argues on direct examination that, well, she was questioned on direct examination that she didn't perform a diagnostic MRI that was just to establish a baseline. And I mean, I think that testimony is pretty sufficient when you have a patient with a history of migraines that have suddenly changed and become worse. And you admit that you just kind of looked at it and thought it was migraines. I mean, I would analogize it to taking your car to the shop because you're having trouble. And all our cars now require a computer diagnostic exam, right? And so it's the equivalent of taking the car there and looking at it and saying, it looks fine to me, as opposed to running the computerized test to see what the other errors are.
I'm sorry. I think my question was a little confusing.
Yes, maybe.
Did the defendants present any expert medical testimony to refute that there was malpractice other than the presentation of the learned treatise?
Both of their experts, I believe, argued the opposite of our experts, that the doctors below met the standard of care because they believed that the standard of care was lower than what we believed it was and what our experts testified to.
And was there any reason why the jury could not have relied on that testimony other than the learned treatise?
I mean, certainly they were able to, but I think the jury instructions in the case also led to some of the confusion that the jury might have had, because the way that the jury instructions were provided basically amounted to a contributory fault decision for the jury, because there was no instruction about how to evaluate comparative fault for Miss Kelly. And in closing arguments, after promising that they wouldn't do it, the defendants both argued that Miss Kelly was partially at fault for not returning to see Dr. Contractor. But I think that's very easily explained because it was the middle of COVID. Dr. Contractor had given her.
Counsel, on the jury instruction, was that objection properly preserved?
The jury instruction, yes, it definitely was preserved.
Can we frame the issues on your jury instruction assignment of error first?
Sure.
My understanding of your assignment of error is, number one, the judge should not have instructed on remote or intervening cause because it was not applicable.
Yes.
And then it sounds to me like the comparative negligence instruction was not something that the plaintiff wanted, because during the charge conference, you were trying to say you're not going to blame the plaintiff for not returning. And
right.
They said no. So that issue only would have come up after they started arguing this in closing argument, that you would want a comparative negligence instruction, right?
Right. I mean, but we never want a comparative negligence instruction. We're the plaintiff. We don't think we committed any negligence.
So you're not, in this appeal, you're not saying that there should have been a comparative negligence instruction given?
No, absolutely not.
Okay.
But if they're going to argue comparative negligence, it's unfair to Miss Kelly, given the jury instructions that were provided, to allow the jury to determine that her potential comparative negligence contributed, because then it kind of eviscerates any possibility that it was the doctor's negligence that caused it. Does that make sense? feel like,
Sort of, but I'm trying to understand what you're challenging. I mean, I understand the first part that you're saying that the remote intervening cause instruction should have never been given, and I'd
Yes.
like to address that. But this is a jury instruction challenge. So are you saying the judge erred by not giving a comparative negligence instruction as well?
no, no. They waived their ability to bring a comparative negligence instruction. So it's improper for them then to argue that Miss Kelly was at fault. It's a very confusing set of situations.
Well, I guess how did the judge err in that regard then?
Well, because the instructions that were provided to the jury left no opportunity for the jury to determine that the doctors were partially negligent and Miss Kelly was partially negligent. If there's not really another explanation of how they could have arrived at the determinations they made, which was that Dr. Horton was negligent, but was not the proximate cause of the injury, and that Dr. Contractor played no negligent role in what happened. It doesn't logically make sense unless you consider how the jury instructions led to that decision.
Okay,
So
so the whole issue is that the judge erred in giving this remote intervening cause. If that instruction were not given, you're saying.
I mean, because if anything, this is a concurrent cause. There's nothing separate about it. Dr. Horton's negligence arose only because of Dr. Contractor's negligence in not providing him the necessary information that he needed to look at the proper places in the MRI or to spend more time looking at certain frames. The reason that the instructions are misleading is because it is so confusing. I mean, and we're all lawyers and you're judges, and we're having trouble dissecting this issue, and a jury of 12 lay people certainly would be confused about how to make these determinations.
Understood. I have one quick question that I want to
Yes.
make sure I'm clear on. It's something that you answered previously, but I want to make sure I'm clear on this. With regard to the first time that the objection was lodged with regard to the guidelines or the learned treatise, what was contained in that objection with regard to foundation? Was foundation discussed at all?
There are 2 points at this right in that time where there were objections made, and I believe in the first objection, trial counsel said that there had been no foundation made, but it was also difficult for him to know what was happening because this had never been produced. It had never been discussed by any expert. It was a general objection. He started with relevancy. I don't know why this matters. This is a neurologist. Nobody's talked about this. I think that's sufficient to point the judge to what the problem was. And it's perfectly acceptable to make a general exception. But
And
then
I'm curious, was the word foundation used in that objection?
I'm not sure. I can
Okay.
look at the record and
because the second objection is the word foundation or reliable authority contained within the objection?
let me check real quick.
And it's okay. You can respond to that. Why don't you respond to that when?
Okay, sure.
Okay. So Attorney Goldwasser, good morning again.
Good morning, Your Honor. I have my phone in front of me. I'm going to set a timer for 8 minutes.
Okay.
And do my best. And I do appreciate the court's courtesies. I kind of outlined that sometimes my knowledge of when certain dates are supposed to fall changes because it changes every year. Thank you for agreeing to do this by Zoom, and I appreciate counsel's courtesies as well. Let me first address in terms of Mr. Calderhead and I splitting our time. My focus will be more on the issue of the question I asked concerning the guideline, and Mr. Calderhead will focus more on the intervening and superseding instruction. But one thing on that, let me just state, with the intervening and superseding, I'm not quite sure that argument even applies when a jury was not left in a position to address causation for two defendants. It was only one that they had to address because standard of care had been met with the other. Your Honor, Judge Moore, you initially asked Ms. David about whether there were defense witnesses who testified that Dr. Contractor met the standard of care, and there was. Not only did Dr. Contractor, who was a board certified neurologist, state that she complied with the standard of care and outlined her treatment methodology and plan, we also brought in Dr. Alexander Merkler, who is a neurologist in New York, who also laid a proper foundation. There was no objection to his testimony, and he stated that the standard of care was met.
And is it my understanding that the plaintiff presented one expert with regard to standard of care?
As to Dr. Contractor, yes, Your Honor. There was a
Okay.
radiologist who opined with respect to Dr. Horton, who is a radiologist. But as to a neurologist, it was Dr. Mankowski who testified.
Okay.
Dr. Mankowski, of course, did say that the standard of care had been, there was a departure from the standard of care, as one would expect, or we would not have even gotten to the point of presenting it to the jury. This was a 2-week trial. Both parties outlined in detail the basis for their cases. And the gist of the case focuses apparently on this MRI that was ordered by Dr. Contractor in October of 2019, in which Dr. Contractor ordered an MRI as a baseline, which is something that she does with respect to all of her patients because she hasn't seen the patient. She knows she has a longstanding history, and just to see what's going on. The MRI was read and interpreted by Dr. Horton, and the only finding read by Dr. Horton or reported by Dr. Horton was that there were some white matter changes, which, as Dr. Contractor testified, were consistent with what she would have expected. There was no reference to anything else. Ms. Kelly returned at the end of the year, went through the findings with Dr. Contractor. She was told to follow up, and that follow-up did not occur. Now, just by saying that, we are not stating that there was a comparative fault of Ms. Kelly. What we argued with respect to that was that that the patient always has a right to decide what treatment they want. If she didn't want to come back, that's fine. But one cannot blame a physician if a patient fails to appear. And the reason why that was raised was that the plaintiffs essentially had 3 arguments against Dr. Contractor. The first being that the initial examination was inadequate. The second being that the MRI should have been ordered with contrast rather than without. And third, there should have been better follow-up to make sure that Ms. Kelly had a repeat MRI in a year, which had been ordered for her. The focus of this appeal concerns this MRI and the MRI that was ordered without contrast. Now, the MRI without contrast seems to be somewhat of a red herring because as the testimony presented itself and the whole basis of the claim against Dr. Horton is that the lesion is detectable on the MRI, and that's the MRI without contrast. The MRI without contrast showed the item that seems to be the issue, but was never seen by Dr. Contractor because it hadn't been reported to her to look for.
So Dr. Horton missed it.
He missed it. He stated that he did. Now, in radiology, Mr. Calderhead can speak to it better than me. There's reasonable misses in radiology. So the fact that it wasn't detected at the time doesn't mean it was a deviation, and that was their argument. The jury felt otherwise as to Dr. Horton, but that is not the case with Dr. Contractor.
Can you help me understand why? Because I thought you were going to go into this. Why, in closing, it sounds like during the charge conference, there was a discussion about whether you were going to talk about her failure to follow up.
Yes.
And lay blame. And I thought the answer was no, we're not going to blame her. And then in closing, there is that discussion. And you were going to explain why you all said she didn't follow up, and like what was the point of that?
The point of that was to show that with respect to the third allegation against Dr. Contractor, that it's her job to call the patient and make sure she does things. The argument is that's up to the patient. It is
Okay.
not a physician's responsibility. And Dr. Merkler testified to that, as did Dr. Contractor. I know I'm running short, so let me get back to the learned treatise issue and the waiver and whatnot. Judge Zayas, you asked if foundation was ever stated as the basis. It was not. If the court looks at the transcript, pages 832 through 831 and 832, Mr. Newman and Chambers outlined the basis for my starting to ask a question about the American College of Radiology. And the arguments were that he is a neurologist and that the document that I was intending to ask about was not presented prior to beginning of trial. Those were the two arguments. There was never an argument raised about foundation. Now, appellant counsel referenced earlier that there were certain pages, I believe pages 9, 10, 9, 11, or 903, etc., in which Mr. Newman outlined further the issue of learned treatise. That was the following day in the morning where Mr. Newman wanted to create an additional record after the witness had been dismissed. That issue was waived. Our position is that well, let me back up. Appellant counsel also said this morning that it was not a learned treatise, but the whole argument raised in the brief is that this reference was a learned treatise and it was hearsay. So I'm a little confused whether this is a learned treatise argument we're arguing about or not. If it is a learned treatise, that issue was completely waived by failing to raise the appropriate objection. Under Evidence Rule 103, there must be a specific basis for the objection. The only basis for the objection given at the time the witness was in the courtroom was based on the fact that he was a neurologist, not a radiologist, and the document had not been produced to counsel in advance of cross-examination. Under the law in Ohio, and as the First District has concluded, in fact, I believe two of your honors were involved in the decision, Judge Zayas and Judge Krause, in the decision of HSBC Bank versus Gill from 2019, in paragraph, I'm out of time. Paragraph 5, the court.
I'll give you time. Go ahead and wrap up. It's fine.
Okay, thank you. That the court referenced that it is an abuse of discretion standard. Judge Hathaway did not abuse her discretion. In order for there to be a reversal, therefore, there must have been a substantially prejudicial impact on the plaintiff, and in this case, over a 2-week trial with one question and experts testifying to the contrary, that was not the case.
Thank you. Thank you.
Thank you, Aaron.
Good morning again, Attorney Calderhead.
Good morning, and may it please the court. I represent Dr. Horton, the radiologist in this case, just to remind everyone. The issue with regard to Dr. Horton and the causation issue raised by plaintiff's counsel, I think is a bit like getting the cart before the horse. And what I mean by that is Dr. Horton was found to be not liable in this case because of causation. And what plaintiff's counsel, appellate counsel has done is ignored the main thrust of the causation defense on behalf of Dr. Horton. And that's related to the testimony of Dr. Nicholas Volpe, who is a neuro-ophthalmologist, which is a fancy way of saying a subspecialist eye doctor out of Northwestern in Chicago. And he's the only eye doctor that testified in this case. And he testified specifically that the alleged miss by Dr. Horton and the alleged delay in diagnosing the meningioma in this case did not cause Miss Kelly to lose her vision. The fact that the patient's vision changed so precipitously prevented earlier detection and intervention to prevent it. He, in great detail, explained how, as a neuro-ophthalmologist, he's involved in monitoring such patients. And then looking at the imaging in this case, given the nature of the meningioma and the patient's optic nerve, this was a sudden, unexpected onset that even through monitoring, which is what the plaintiff's claim would have happened between the first read by Dr. Horton and the ultimate diagnosis, it would not have prevented her vision loss.
So that was his main defense. But what was the point of the remote intervening cause instruction? What was any other defense? Were they blaming each other, the doctors? Why have that instruction included?
Yes, and thank you for bringing that up, Judge, because of going into closing arguments and going into jury deliberations, there were two separate and distinct arguments by plaintiff's counsel against two separate and distinct physicians, Dr. Contractor and Dr. Horton, that had independent obligations and duties to the patient. And for Dr. Contractor, the allegations were before Dr. Horton read the MRI that Dr. Contractor ordered, and then after. So Dr. Horton read the film, the MRI, on December 6th, and then there was a follow-up visit with Dr. Contractor, and the plaintiffs alleged that she was negligent, Dr. Contractor, in that follow-up visit by not doing more, including not picking up the meningioma on the imaging that she also reviewed. But more importantly, the plaintiffs argued that Dr. Contractor had a duty to order additional studies because this was a non-contrast MRI, and contrast MRIs are the proper MRI to investigate for a tumor. So going into closing arguments and jury deliberations, that was appropriate because the jury could have found that failure by Dr. Contractor broke the causal chain and was an intervening superseding. That's the only reason that was requested.
So
but
even though
the jury didn't get there.
Even though your client, I guess he admitted that he missed the tumor, right?
He admitted that with the benefit of hindsight, there was an abnormality there. However, we argued it was a reasonable miss. Clearly, the jury did not find in our favor on that. That's why we called Dr. Volpe to talk about the causation issues in this particular.
But you had Dr. Volpe, but you also, did you argue in closing that even if you don't agree with Dr. Volpe, that somehow it was Dr. Contractor was the intervening or the cause of the problem here? Is that what was argued?
On closing argument, I argued that there was allegations of subsequent negligence as well, and that it's up to the jury to decide whether that would impact the the causal chain. I didn't spend much time on it, to be honest, on that particular issue on closing. And sitting here right now, I don't even recall if I brought it up in any detail. Honestly, I don't recall.
Counsel, I want to make sure I understand kind of the timing on the jury instruction. I believe the charging conference, there was discussion and eventually agreement with the understanding that there would not be a reference to any negligence on behalf of the plaintiff. Is that right?
Yes, and there was no reference to any negligence on behalf of the plaintiff.
So coming out of the charging conference, everybody was in agreement on that instruction.
Yes, plaintiff's counsel, raised the issue of whether there was going to be any blaming of the patient on any negligence. And we said there's not. And we did not blame her. We brought up the facts of the case, which was her right to follow or not follow recommended care. Every patient has a right. It's not a negligence issue at all. It's a fact of the case and it's relevant.
But following the charging conference where everybody was in agreement, was there any objection raised again with respect to this jury instruction? There was not. From my memory. In fact, there was never even brought up the issue with regards to that. And plaintiff's counsel on page 1648 of the record on closing argument, after defense counsel testified, addressed the issue and accused defense counsel of blaming his client and saying it was the client's fault.
So he was on alert. And if he felt that way at that time, he had every right and obligation to raise that issue and present a comparative negligence charge if he wanted to do that. And he chose not to. So that issue is waived.
Attorney Calderhead, I just want to clarify something. I want to, in a way, I'm super clarifying it, okay?
All right.
All right. So as you've already stated that that it was that it was clear that negligent on behalf of the plaintiff was not being pursued. My question is this: was there any testimony at any time that the patient's delay in returning to the physician was a contributing factor?
There was no testimony by any expert witness on that I recall at this time on that particular issue. But keep in mind that the plaintiff's whole argument was that there needed to be additional monitoring through neuroimaging, which had been recommended by Dr. Contractor and not followed up by the patient. So it made it a relevant issue based upon the arguments that plaintiffs were making at trial.
Okay, thank you.
I see my time's up, and
Yes.
I would
So I
ask
have
you
a quick question. So you're saying the plaintiff was arguing that the doctor should have contacted her for further monitoring?
that was an argument that was made by the plaintiff against Dr. Contractor that she needed to be following up on the patient. And so it wasn't just the patient's obligation to follow up with Dr. Contractor. And I think that was part of the whole COVID argument as well, and healthcare and how people weren't seeking out healthcare. All right.
All right, thank you.
Thank you very much.
So Judge, I went back and looked at the objection, and while I'm pulling it up again, I just wanted to point out that the hearsay rule requires one of three foundations to allow in a learned treatise. And this is assuming that this is a learned treatise. One, the expert relies on the treatise for an opinion. Dr. Mankowski did not rely on the treatise. The expert states implicitly or explicitly that the treatise is a reliable authority. All that Dr. Mankowski said was that he was aware of it. He didn't testify to its veracity or anything else about it. And the third is that the treatise is a part of the expert's publication. That obviously didn't happen either. So under either standard, we would argue it was error because there was absolutely no foundation. And trial counsel.
That's why it raises the question. That's why possibly it raises the question of what was the objection that was lodged? What was the nature of that objection, and what was it intended to encompass?
Trial counsel's objection first argued relevancy, and then he said, we're now looking at documentation and literature or guidelines that I don't believe were produced in discovery, weren't identified by any experts that were going to be used in this case, and it's inappropriate to go down this line of questioning with a neurologist. I think I think all of that leads to a foundation objection without using the word foundation.
Because while you're arguing for the first time that it wasn't a learned treatise, that still brings it into the hearsay realm, even if it's not a learned treatise, right?
Right.
And so then the question becomes, was the objection about hearsay? Was there even a hearsay objection?
He does object to it being hearsay in that lengthy dialogue with the court later. And I mean, it's still error after that point because the court could have said, okay, you're right, we shouldn't have admitted that. I'll give the jury a warning that they can't consider it. He still had an opportunity to cure the defect, and the court had an opportunity to cure the defect, and it didn't. So the jury was permitted to rely on that testimony, and we don't know what they relied on. There's no interrogatories to say why they decided the way they did. But I do think that he preserved the issue immediately, and if not then, definitely later. And
I think that regardless, I think that the other thing that I would be, and you were asked about this earlier, is for you to address harmless error. So,
I think under either standard, it is an error because it wasn't harmless. It was the only external testimony or the only external source that defined the standard of care. And it made Dr. Mankowski appear that he doesn't even know the basics of his own field when it wasn't even his field and it wasn't anything that anyone had relied on and something that we're not sure he'd ever even seen, just that he was aware that this organization exists and makes criteria.
Why couldn't the jury rely on the testimony of the defense experts?
They could have, but we don't know what they relied on. And so to allow this in under the Moritz case is automatically error. Whatever standard you use, I think it's error. Because in Moritz, basically the same thing happened. In that case, it was a diagram and it was given to the jury, but the court's decision says that impermissibly admitting evidence from a learned treatise when it doesn't meet the qualifications is automatically error. And to follow up on Mr. Calderhead's points, we did preserve the issues. Subsequent negligence, Dr. Contractor's negligence, if she creates a situation that Dr. Horton could create negligence, that's foreseeable to her. And so none of this should have been a surprise to either of them. They all kind of merged their negligence together and it's all intertwined. Nothing was a superseding cause. Nothing was different. Dr. Horton had to rely on Dr. Contractor. So her negligence is imputed to him when he also isn't looking properly and carefully. That was his own negligence, but he didn't know to look properly and carefully at specific places because she didn't tell him what to look for.
Well, thank you for your arguments this morning.
You're
We're going
welcome.
to take the matter under submission, issue a timely decision. We wish everyone a wonderful remainder of the week and a great weekend.
Thank
And
you.
that concludes the proceedings for today.